So welcome everybody. My name is Trevor Tim. I'm Executive Director at Freedom of the Press Foundation. Thanks so much for joining this special event. The topic today is the prosecution of Wikileaks founder Julian Assange and the potentially devastating impact that this case could have on press freedom in the United States. So many of you know, next week the UK High Court will be holding a hearing in this case, and they will potentially determine whether Assange can get extradited to the United States to face charges under the Espionage Act. And so we're really excited to have three of the nation's leading constitutional and civil liberties experts joining us today. And we're really targeting this event for people who are skeptical of this case, for journalists and members of the public who may not like Julian Assange, the figure, or the publisher, or the person. And so we're not trying to change your views on Julian Assange, the person, but we do hope to convince you of the importance of Julian Assange, the case. And so we are especially honored today to be joined by Democratic Congressman Jim McGovern, who represents the 2nd District of Massachusetts in the United States House. He is the ranking member of the House Rules Committee. And most importantly for us, just a few months ago, Congressman McGovern led 16 members of Congress in a bipartisan letter calling on the Biden administration and the Justice Department to drop charges against Julian Assange and halt the extradition proceedings against him, specifically due to the acute dangers to basic rights afforded to journalists every day in this country. So thank you, Congressman McGovern, for your courage and leadership on this issue and for being here today. So I will hand it off to you to say a few opening remarks.
Well, thank you, Trevor. And thanks to everybody on the call here today, and good afternoon. It's a pleasure to join you to say a few words about the Julian Assange case. So this is an important moment in an important case. So next week, as was mentioned, on February 20th and 21st, a hearing will be held in the United Kingdom. During that hearing, a panel of 2 judges will review a prior court decision that denied Mr. Assange permission to appeal to prevent his extradition to the United States. If the judges rule against him, the extradition process to the US could begin. As a member of the United States Congress, I do not have any role in the UK legal proceedings. What I have tried to do is encourage my own government to withdraw the extradition request and bring the US legal case against Mr. Assange to an end. The invitation you circulated for this event starts off by saying, quote, "Whether you love or hate Julian Assange, the United States prosecution of the Wikileaks publisher under the Espionage Act poses an extreme risk to press freedom," end quote. I agree with you. I recognize that Mr. Assange is a controversial figure, and I understand why many people think it was wrong for him to publish classified documents about the US State Department, Guantanamo Bay, and wars in Iraq and Afghanistan. But there is no question in my mind that prosecuting him under the 1917 Espionage Act for publishing that material is a terrible mistake that undermines freedom of the press. As I wrote in the congressional letter to President Biden that I led last November, the Espionage Act was intended to punish government employees and contractors for providing or selling state secrets to enemy governments. It was not meant to punish journalists and whistleblowers for informing the public about serious issues that some US government officials might prefer to keep secret. And I believe that the Department of Justice got it right back in 2013 when it declined to pursue charges against Mr. Assange for publishing the classified documents, because it recognized that the prosecution would set a wrong and very dangerous precedent. That decision should never have been reversed. And as you know only too well, the freedom of press is under attack all over the world. One form of attack is criminalization, a go-to strategy for many authoritarian leaders. The last thing we need is for the United States to go down the same path. So I hope the UK judges rule in favor of Julian Assange next week. And regardless, I will continue to call on President Biden to find a way to bring his prosecution to an end. As the hashtag says, journalism is not a crime. Reporting on the activities of government is necessary for democracy, especially on when it comes to the life and death issues of war and peace. So thankfully, there is still bipartisan support for this core idea. It is vitally important that you continue your advocacy on Mr. Assange's case, and I promise to continue to be wind at your back. So thank you very much.
Well, thank you so much, Congressman, and we couldn't have said it better ourselves. And the same goes for us. If we can be of any assistance to you in this case, please let us know. And thank you so much for joining. So today, as I said, we have three of the nation's leading civil liberties experts here. We're so excited to kind of dive into the specifics of this case and why everyone should be concerned. But first, I want to start with Carrie DeSalle from the Knight First Amendment Institute. You know, for many people who may not know what the Espionage Act is, they see, you know, the word espionage and they assume that, oh, this case must be about spying. You know, before we get into the specifics of this case, maybe you could talk a little bit about the dangers of the Espionage Act and why this case actually isn't about spying at all.
Sure. Thanks so much, Trevor. So the Espionage Act of 1917 was passed mere days after the United States entered World War I, and it really was concerned with foreign spies gathering sensitive defense information and sharing that information with our enemies. But the breadth of the text of the statute sweeps much wider than that. It extends to more than just spies in the traditional sense. And as we have seen, it can extend to whistleblowers who leak information to the press and now to the people who publish that information. Although press actors face liability under really any provision of the Espionage Act, and here I'm talking about Section 793 in particular, the principal threat to press freedom comes from one particular subsection, Section 793E. And that provision criminalizes communicating or retaining materials related to the national defense, where the recipient or the person keeping those materials is not authorized to receive them. So I hope by that language you understand how very broad this provision is. And so the plain sweep of this provision extends to sources who disclose confidential materials to a journalist, and in fact to the journalists who receive and then publish those confidential materials, and really for any publication that continues to publish those materials. As I mentioned, it also extends to retaining materials, the classified information that shouldn't have been disclosed under the Act in the first place. So if any of us have a hard copy newspaper where classified information is reported on, we too have violated this provision. So the text of the Espionage Act is incredibly broad, and I think much broader perhaps than Congress even initially intended when they passed the Act. That said, throughout the entire 20th century, basically throughout the entire 20th century, almost all Espionage Act prosecutions centered on the disclosure of classified information to foreign governments. There were 0 prosecutions of publishers of leaked information and only 2 prosecutions of the people who leaked information to the press. The first was Daniel Ellsberg of the famed Pentagon Papers case. And the government ultimately dropped that prosecution after it had engaged in misconduct in conducting its investigation. And the second was a person named Samuel Morrison, who was a naval analyst who disclosed, I believe, satellite imagery of Soviet ships to an English kind of naval publication called Jane's Defense Weekly. And that was the only case in which a leaker of information to the press was prosecuted successfully under the Espionage Act. And President Clinton actually pardoned Samuel Morrison in 2001. So it wasn't until really the George W. Bush administration and very significantly under the Obama administration that we started to see prosecutions of leakers of classified information to the press, of whistleblowers. And then, of course, it wasn't until the Trump administration that we saw a prosecution of a publisher of that information.
Absolutely. Well, so Cindy Cohn, Executive Director of EFF, how about we turn to you? You know, if we, or at least if I judge by our Twitter mentions, anytime we mention the Assange case, I think a lot of people who haven't been paying attention think, oh, this must be about the 2016 election, or the leaks of, or the publication of DNC emails, Hillary versus Trump and Russia. However, none of those things are mentioned in the indictment at all. And so wondering if you could provide some of the facts involved here, and what exactly, what is the underlying facts in the Espionage Act charges, and when did they actually happen?
Yeah, so everything alleged in the complaint happened before May 27, 2010. And that's the date that Chelsea Manning was arrested. Everything in this indictment is about the leaks that Chelsea Manning made of information that she had access to in her role as in the Army intelligence. So nothing about, I mean, 6 years, nothing about the 2016 election is in the indictment. Most of it involves activities between 2019 and 2010. 2009 and 2010. So the actual things that are in the indictment are a set of charges against unauthorized obtaining of information, as Carrie pointed out, obtaining classified information or defense-controlled information. Not all the information was actually classified, much less classified at a high level. Unauthorized obtaining is about half of the charges, and the other half of the charges is unauthorized disclosure. So getting classified information and publishing information. Those are really the two central espionage kind of things that they did. And then the other inside the counts are the particular things. So there was 75,000 Afghanistan significant activity reports. There were 400,000 significant activity reports having to do with Iraq. Again, this is all pre-2010. The Iraq rules of engagement, 800,000 Guantanamo detainee assessment reports, and 250,000 State Department cables. So it's a lot of information, for sure. There's no question that Chelsea Manning made a lot of information available, but none of this has anything to do with the 2016 election. It all very, very predates. It's some of the first big leaks around the wars that the U.S. was engaging in Afghanistan and Iraq. That happened a long time ago. And I think that's really important because a lot of the feelings that people have about Julian Assange and maybe even WikiLeaks really come much, much later than this indictment. And I think there's a lot of I have a lot of worry that will color things. There's a statement, that lawyers all learn, which is, bad facts make bad laws, which is that if you're judging based on the person and what the whole life of what the person has done, you might make a different decision than whether you're narrowly focused on the particular things that are in the indictment. So it's really important for those of us thinking about that to do that, not just because I think it's not fair to prosecute anyone, even somebody who you don't like, based upon things that aren't in the indictment, but that you otherwise don't like about them. But also because of, I think, the real reason we're here, the broader reason we're here is the implication for other journalists, because obtaining information that the government doesn't want you to have and then publishing it so that the American people can have exercise their democratic rights to make judgments about who they're going to vote for based upon the truth is the underlying value that the Espionage Act threatens and that this prosecution threatens.
Absolutely. Well, so speaking of that, now we turn to Ben Weisner, who is ACLU's director of the ACLU's Free Speech, Privacy, and Technology Project. Ben, I'm sure there are many people who may be watching this who dislike WikiLeaks or dislike Julian Assange, including in the Biden administration, who are saying, well, I don't think WikiLeaks is a news organization. I don't think Julian Assange is a journalist, so we don't need to worry about press freedom in this case. What do you say to them?
Well, I think it's not just people perhaps in the Biden administration, but a lot of other journalists who are sure in their bones that however aggressive they might be in their reporting, they're not WikiLeaks, and that it should be easy to distinguish between them. Everyone knows. The problem here is that the Espionage Act, as Carrie explained, doesn't have the word journalist in it. It broadly criminalizes the retention or dissemination of national defense information, which gives extraordinary discretion to prosecutors to criminalize everyday activities. And let's focus on what I think most people would consider mainstream national security investigative journalists do. The New York Times has on its website a submission system for anonymous sources to submit information without being detected. It's called Secure Drop, and Trevor, your organization maintains that technology. It's basically the same technology that WikiLeaks used in order to obtain secret anonymous disclosures of documents. If someone, say, submitted to the New York Times Trump's complete tax returns through Secure Drop, the New York Times wouldn't know if that came from a whistleblower in the IRS or Iranian intelligence. But the New York Times is asking itself, would the publication of this material serve the public? Should the public in a democracy have this information? Does the public have a right and a need to know this kind of information? And that's what they're deciding when they determine whether this should be published or not. If we have a conviction of Assange here for doing that, for publishing the government's secrets without their permission, whether you consider him a heroic journalist or a pain in the ass, you have basically just criminalized national security investigative journalism. That does not mean that the day after this conviction, the New York Times and Washington Post reporters are going to be rounded up and herded off to jail. It does mean that every lawyer who works for a newspaper is going to be examining everything before publication with a new threat in mind. The threat that if the government doesn't like it, the publisher and the reporter can be sent to prison and convicted of a felony, something that has not happened in the 100-year history of the Espionage Act. So what we need to worry about is there a way to meaningfully distinguish what is charged in this indictment from what again, what you would say less controversial national security journalists do on an everyday basis. In 2013, the Eric Holder Justice Department declined to pursue criminal charges here because they could not make that distinction. They called this the New York Times problem internally. They couldn't square the circle. They couldn't figure out a way to criminalize what Assange did in 2010 without criminalizing what the New York Times did in 2010, because the New York Times published the same documents that Assange is charged with having disseminated in this case. In a very unfortunate reversal, the Jeff Sessions Justice Department in 2017 reopened that case and decided to bring these charges. Unfortunately now, the Justice Department under Garland is adopting what I think is the institutionalist position of not changing its position based on a change in administration, even though that's precisely what the Trump administration did before. So I think it's unfortunately quite unlikely, and I think we should be candid about this, that these charges are going to be dropped, that the extradition efforts are going to be just dropped. If they were going to do that, they could have done that. I think what's more realistic at this point is, look, Assange has already spent almost 5 years in a maximum security prison, and there should be a way to resolve this case without a precedent-shattering and precedent-setting conviction under the Espionage Act that will make life very, very complicated for national security journalists going forward.
Yes, and actually we'll have a follow-up question for you about that in a little bit. But actually I want to take what you said earlier about what exactly would happen if this case were to come to fruition and Julian Assange would be convicted. And so maybe we can go to you, Carrie. It's possible that this case ultimately ends up in the Supreme Court. The day after an Assange conviction, what are you specifically worried about when it comes to, say, journalists at the New York Times or Washington Post? Are there particular stories that they may have been able to do in the past that would become more difficult And, how do you see national security journalism in an era where an Espionage Act conviction may be possible?
Yeah, so as Ben just explained, I think a successful prosecution of Assange in the United States would jeopardize national security reporting across the board here. I think actually the mere fact of the prosecution itself, regardless of what happens, is already sending a chill down in-house lawyer spines and potentially the reporters themselves when it comes to publishing information that people have leaked to them, defense information. So I actually already worry about the effects of this prosecution on national security reporting. But certainly a successful prosecution of Assange in the United States would result in an overhaul of the kind of risk analysis that goes into publishing any story that relates to classified information. And, to the extent this case gets to the Supreme Court, I do worry about the court's view of whether or not journalists or just publishers of this kind of information should be held liable under the Espionage Act. They haven't addressed that question squarely in the past. They certainly haven't addressed the question of whether or not the First Amendment places any limits on that kind of liability. And it's a total open question for me. I'd be curious to hear Ben and Cindy's views on that, but I would be very worried that the Supreme Court would reject any First Amendment limits on liability that journalists face under the Espionage Act. And I'd also be concerned about the damage it might do to other precedent that journalists have come to rely on. And I'm thinking here of a line of cases that establish that an act of publication doesn't lose its First Amendment protection merely because it involves the publication of stolen information, so long as the publisher wasn't involved in the initial theft, the initial illegality. And Bartnicki versus Vopper comes to mind. There are other cases, Florida Star, where a news organization published the name of a rape victim, even though that was criminal under Florida law, but the police department was the entity that had published the name in the first instance. And so the newspaper had the benefit of the First Amendment protection for continuing to release that information. And I worry that the court might backtrack on some of that precedent. And that would do real damage to the kind of overarching principle that the press and others have a right to publish truthful information on matters of public concern, because as Cindy mentioned before, that's the information we need to make good decisions when we vote in the next election.
Absolutely.
So just to give my 2 cents on what I think the court would do. I think we tend to remember half of the Pentagon Papers case and forget the other half. The half we remember is that the Supreme Court said that the government could not engage in a prior restraint. It couldn't prevent the publication of classified information that had been leaked to newspapers by the government. But it didn't foreclose, and in fact, it quite left open the possibility that newspapers could be prosecuted if the publication violated a federal statute. So the only kind of signal we have from the Supreme Court from half a century ago is that there may not be a constitutional limitation here. Now, having said that, I think there are real problems with the Espionage Act that even the Supreme Court would have to recognize. For example, it doesn't criminalize, except in narrow contexts, the publication of classified information. It criminalizes the publication of national defense information. And the way that that is defined essentially is so overbroad that I do, and also vague, that I think that there are real constitutional problems that if the Supreme Court took this up would have to acknowledge and would at a minimum have to narrow the reach of the Espionage Act in some way, or to give those terms meanings that are narrower than their plain meaning in order for it to be upheld.
Cindy, one of the points that Ben made earlier was about news organizations using technology, specifically secure drop, but a whole host of encrypted technologies in the past 10 years. Of course, Electronic Frontier Foundation is at the absolute forefront of the intersection of technology and civil liberties. And so, are you concerned about all of the talk in this indictment about, communicating over secure chat services or transferring files, or even using technology to, anonymize sources? Are there dangers here for journalists as well?
I think so. We see this. This is not unique to charges against journalists. We see prosecutors a lot of times trying to use the fact that technology to protect privacy was used as some kind of argument about intent or making something sound just scarier than it is. And this indictment is kind of full of those kinds of things. And I think it's a technique that um, is losing its power in general, because I think lots of people now have experience with encrypted things and they understand that it's just a tool and it's not scary or bad, but we're still in this period where, and I think that will only continue, but at the same time we're seeing efforts in the UK right now and other places, even in the United States, to try to criminalize or at least make it impossible for people to have a private conversation. And this is going to have serious implications for journalists. So, yeah, I think that it's an effort to use, what lawyers sometimes call atmospherics to make what happened sound scarier or perhaps different than what, the Pentagon Papers case. And so to give some people the idea that what WikiLeaks did was somehow different than normal journalism. But I think it's very problematic, and it's something that we need to continue to call out when we see it, because it's really not the case that trying to protect your sources and using technology to help you do that is anything different than trying to protect your sources. That's an important part of journalism, and we need to stand up for it.
I agree more. Ben, you mentioned earlier about Merrick Garland, the Attorney General, and in the White House. So, anytime the White House is asked about this case, they, avoid the issue entirely. They claim, oh, we can't interfere in Justice Department cases. Do you think this is a legitimate excuse in this case? And regardless, what is your message to the White House and the Attorney General, knowing that, they also probably dislike Julian Assange?
Well, I actually think it's the right public answer. I don't think that the White House should be interfering with the independence of the Justice Department. And, the irony is that we got here because, different attorneys general have different views about how a case like this should go forward. But as a public answer, I think that's right. Now, the reality is this isn't an ordinary criminal case, and it has foreign policy implications, both because Assange is an Australian citizen. The Australian government has already asserted publicly that it would like to see these charges dropped and it would like to have him returned. And that is obviously the province as well of the White House and of the State Department. The other is the theory of criminality in this case has a real global dimension, one that should be of concern to the White House and the State Department. And that is the US is taking what I still think is the extraordinary position that our own criminal secrecy laws can be applied against a foreign publisher living overseas. And that is a real Pandora's box. Let's posit that the Wall Street Journal's reporter Evan Gershkovich might have violated a Russian law. Russia has some pretty bad laws governing what journalists can do. I think most Americans would say it's outrageous that Russia would think that its own crazy secrecy law should apply to an American journalist who's just doing his job. But how on principle do we distinguish when we're applying a much maligned century-old law against a foreign publisher and saying that our secrecy laws, sort of criminally bind him? And I think for that reason, this should be a matter of concern to the State Department and the White House because of the precedent that it's going to be setting for global press freedom, because of how it's going to implicate our own ability to advocate for press freedom overseas, which we still do, as hypocritical as that may sound. So, I would hope that behind the scenes, if not in front of them, that there is some interagency task force that is working together to see if there's a way to resolve this case, return Julian Assange to Australia without bringing him here and putting him in first a jail cell in Virginia and then in a federal prison.
Well, so that brings up an interesting question that one of the attendees brought up. They're essentially asking, where are the news organizations on this? I think the civil liberties organizations, obviously I'm biased with everybody in this room. I think the civil liberties organizations have done a good job of raising awareness around this case. Yet the news organizations, in the case of Evan and his horrible detention in Russia, there is a very sustained campaign by the Wall Street Journal and many news organizations to make sure that this case does not get out of the headlines, which is great. But with the Assange case, they may have said the right thing once or twice, but you don't see that type of a sustained attention. What is the role of newspapers here, and how can they better help make the Justice Department realize that this is a serious issue? And that's really a question for anybody who wants to grab it.
I mean, I think that the decision by the major newspapers to try to distance themselves from WikiLeaks and just hope that it never blows back on them is going to be one of the more short-sighted things that has happened in journalism in a while. And there was a pretty strong standing up for Assange in the early days, and it is really it's really withered. And instead, we see lots of attempts to do kind of attacks on Julian as a person, as if that matters. It's not about whether you're a journalist; it's about whether you're engaged in journalism. And I don't think there's a credible argument that WikiLeaks wasn't engaged in journalism by publishing this information. So I think it's short-sighted. I think they're going to come to regret it. I think the idea that there's going to be a singular Julian Assange application of the Espionage Act and this tool won't be attractive to future prosecutors is just it's just wishful thinking. And so I think they have quite a role that they could take up to talk about the broader implications. And again, I don't think you have to pretend like Julian Assange is the best human who was ever born in order to talk about the principles. Journalists have to do that all the time. And I worry that they're letting they're telling themselves a kind of fake story about the implications of this case.
Yes.
Yeah, it's not too late, right? I mean, we have seen so the news organizations themselves are mostly on record saying that they find this troubling. You're right. What's different is that most of them did it once, checked the box, and said, now I can stay away from this yucky subject. But now would be a good week for news organizations to start editorializing and saying that it's time for a sane resolution of this that does not criminalize important national security investigative journalism. So if there are any journalists on this call, it really isn't too late for journalists to come together and state publicly how this prosecution will really have the effect of depriving the public of information that we need. If we look back, just at our own careers on this call, the issues that we've worked on over the last 2 decades, and we've all worked together on some of those issues. Almost everything that we know about the government's criminality and wrongdoing, we know because some courageous source shared the information with some intrepid journalist who published the information over the vociferous protests of whoever was in the White House, who said that they'd have blood on their hands if they published it. And this is how we know about the archipelago of black sites where prisoners were tortured, that drone strikes kill innocent people, that the government developed and deployed a system of mass surveillance without our consent or knowledge. We know this because people violated the Espionage Act, and journalists published that information. And once journalists have to face what technologists would call a new threat model, which is the precedent that someone has been convicted of a felony for doing precisely that, for prying out the government's secrets and publishing them over the government's objections, we're going to see a lot fewer of those stories.
Well, I think that's a perfect place for us to end this panel. I will remind everybody that actually just yesterday, speaking of galvanizing forces, we released a letter with 35 law professors who wrote to the DOJ, telling them that this case is a direct threat to the First Amendment. And you'll probably be seeing more of those, hopefully in the future. All of our organizations have signed on to multiple letters to the Justice Department, and I think now it's, as Ben said, it's up to the news organizations to start beating the drum regularly as well. Finally, we'd like to actually share a video that we made for social media that tries to hammer home this message. This video is aimed at those who may not like Julian Assange, but would be worried about press freedom in general, and what journalists, the dangerous journalists, might face if, say, a President Trump or somebody like him returned to office. So we're going to play that now. But in the meantime, thank you so much to all the panelists. Thank you to the congressman, and we will see you all online soon.
Thanks.
For decades, news outlets have depended on the right to publish government secrets. But all that could change if President Biden's Justice Department finishes what Trump started, prosecuting Wikileaks founder Julian Assange under the Espionage Act.
Everybody back there, the fake news media, look at all of them.
Donald Trump repeatedly calls journalists
Enemy of the people.
and he's already promising a crackdown on the press.
Yeah, they say, it's okay, you're going to jail.
The only thing stopping him is the First Amendment.
The nation's Bill of Rights.
It protects the rights of journalists to publish the truth,
We're going to go with the story, because the terror is right here in this room.
whether the government likes it or not.
Today, the Trump administration announced new criminal charges for Julian Assange under the 1917 Espionage Act, a terrible piece of legislation and rife for governmental abuse.
The government is now trying to criminally prosecute people for publishing secret stuff, and newspapers and magazines publish secret stuff all the time. That is the bread and butter of what we do.
The Espionage Act charges against Julian Assange have nothing to do with hacking, spying, or even espionage. They also have nothing to do with the DNC emails or Russia.
I know you. Given everything else that we know about the WikiLeaks guy, I can feel through the television right now your mixed feelings about what I am saying.
Everything that Assange is charged with under the Espionage Act happened in 2010. Assange is accused of speaking with a source, convincing her to give him documents, receiving those documents, and then publishing some of those documents.
Run that, baby.
In other words, acts that journalists engage in every day.
So much has been written about this in recent days as a result of the substantial leak.
The Obama administration didn't like Assange, but they chose not to prosecute him.
2004 to 2009.
They knew it would create a dangerous legal precedent. But when Trump got into office, he indicted Assange. Trump doesn't care about destroying press freedom.
Keep your voice down.
What a stupid question. You are a rude, terrible person.
For him, that's a feature, not a bug.
But it should concern Biden if he really thinks
Journalism is not a crime.
And it should concern anyone who wants the press to freely report on Trump's abuses.
I'm the president of the United States. Don't ever talk to the president that way.
By God, I'm going to fight that son of a bitch in paper.
The Assange prosecution would hand Trump the perfect weapon to go after the New York Times and Washington Post.
Police in this small Kansas town raided.
Prosecutors would also be emboldened to crack down on local journalists across the country. You don't have to like Julian Assange. This is not about him. It's about the future of the Fourth Estate and American democracy.
whether this case goes forward will be a part of Biden's legacy. The future of journalism is in his hands.
It's time for anybody who cares about press freedom to put their personal feelings about Julian Assange aside. Tell the Biden administration to drop this dangerous prosecution immediately.
Thanks again, everybody. We'll see you next time.